justice legislation, and we have three speakers. Leah Kelly from Environmental Integrity Project, Emily Osenrock, I pronounce it right? I always mess it up. Eisenrao, see, that's the southerner in me. Gotta pronounce the C sound. From the Maryland Environmental Law Clinic, and Lisa Garcia from Earth Justice and formerly of US EPA. So who's speaking first? And can you just do like a quick intro so we can kind of catch up with yourself? I'm not going to do the intro to everybody.
Oh, sure, yeah, no, that's
Okay, go
fine.
ahead.
So I'm Emily Eisenrow. I'm a staff attorney with the University of Maryland Law School's Environmental Law Clinic.
Got it.
Okay. And today we're going to talk about environmental justice legislation in the region. And before I start talking specifically about legislation, I kind of wanted to go through some of the different types of stressors that can factor into community health. So for the first slide, it's, and by no means is this list exclusive, it's just a couple examples. So the first slide is things like poverty, unemployment rates, education level can all be indicators of, can all be stressors in a community and can affect health. The amount of sensitive populations in a community can also be a factor in determining the health of that community. So children, the elderly, and pregnant women are all especially sensitive to stressors. And then persons with certain health conditions, things like asthma and heart disease are also stress can exacerbate those conditions as well. And then there's pollution stressors. So there's air pollution, both major and minor sources, major being things like coal-fired power plants, but also minor sources can also put stress on a community as well. The proximity of a community to highways or major roadways can also affect the health of that community, especially if there's a lot of diesel truck traffic. Diesel exhaust can be carcinogenic. It can affect respiratory health as well as cardiovascular health. Things like pesticide use and proximity to solid waste sites can be indicators for exposure to pollution. And then there's water pollution. So if you are swimming in a polluted waterway or catching and eating fish in a polluted waterway, you could be exposed to harmful pollutants. And most of the legislation and the legislation we're going to talk about, well, I'm going to talk about today, primarily focuses on how to address these environmental stressors that will can compound the other stressors in a community. And there are several communities that fall into the category of kind of overburdened communities throughout Maryland that have stressors on all three of those categories. The way the law is written currently, a lot of those overburdened communities are allowed to continue to be overburdened. And so there's been attempts at legislation to try and address that issue. And the clinic has worked with one of those communities, and I'm going to kind of use that community as an example of how some of these communities kind of fall through the legal gaps. The clinic, as I said, was working with a community here in Prince George's County. It's a primarily African American community that was established in 1908. And then in the 1960s, the area right across the street from that community was zoned as for heavy industrial uses. And today, that area contains several minor industrial sources. Just to give you an example, there are several crushing facilities that essentially take big chunks of material, usually concrete or stone or brick or things like that, crush it up, put it into a big pile. There's also a recycling transfer station. There was at one point an asphalt batching plant in there as well, and I'm not 100% sure whether it still is operational or not. But anyway, that just gives you an idea of some of the things that operate right across the street from this community. And although they're minor sources, they have caused a lot of problems for the community. One of those problems being noise. So the facilities themselves, the crushing facilities, can be very noisy. Loading and unloading trucks can be noisy, and then also the trucks coming down the street. And that noise, the community said, has started as early as 3 o'clock in the morning and can go into the evening, which can be very disruptive and stressful to the community. There's also, for each of these facilities, there are trucks coming and going to each one every day. And those trucks not only cause traffic, but they drop pieces of material on the street, which can be very dangerous. Children walk to and from school on that street, so having big trucks driving down the street while children are walking to school is dangerous. But also, the emissions from the diesel trucks themselves can be hazardous. And then the big one, another problem is dust. As you can imagine, crushing pieces of stone can cause quite a bit of dust if it's not treated. Usually they use water to try and suppress the dust. But also the trucks, the entranceway to this industrial area, the road is quite dusty, so when trucks go in and out, they're kicking up dust. And then, they also have big stockpiles of material, so dust can also come off of the stockpile. And the community has said that, they've experienced big clouds of dust coming and settling in their communities to the point where cars are covered, houses are covered, it's getting inside of their houses. So the community was already having trouble with some of the effects of the industrial area across the street. So in 2004, there was a proposal to add a concrete batch plant in that area. That facility would have been located a little over 500 feet from the nearest residential area. Diesel truck traffic could increase during peak days up to 370 trucks a day. And then the plant itself would potentially add to the noise level, but also potentially to the dust problem as well. So in Prince George's County, you need a special exception to the zoning plan to construct a concrete batching plant. So the facility applied for that special exception, and there was a hearing. The residents testified at the hearing. But ultimately, Prince George's County issued the special exception for them to site their concrete batch plant there in that area. I forgot to mention, during that hearing process, Prince George's County Health Department did a survey of the residents across the street. They did a survey to see how many people suffered from asthma. And they found about 20% of the population suffered from asthma. And based on that, they recommended that the county do a study on air emissions before they make a decision about whether to site this facility there or not. And that study was never done. So kind of a missed opportunity there. So anyway, so PG County granted the exception, and then the community challenged that grant of the special exception. And in challenging it, part of their argument was that, we already have this burden here, you should really be considering the cumulative impacts of siting this facility in an area where there already are so many problems. And ultimately, they lost that challenge. The next step for that facility would be to get, one of the next steps would be to get a permit from the Maryland Department of the Environment. And to get that permit, the department doesn't necessarily have to consider cumulative impacts there either. So you can see, you know, the county doesn't have to consider the cumulative impacts, the state doesn't have to consider the cumulative impacts, and so the community just kind of falls through the cracks. But during the concrete batching plant issue, a local politician, a senator from the area, noticed what was going on, understood the issues, got involved in the concrete batching plant issue, and then last year she introduced legislation to try and kind of close that gap. And not just for this community, but for, like I said at the beginning, there are several communities that throughout the state that have similar types of burdens. Essentially what the bill says is that MDE was required to construct a cumulative impacts assessment if they receive a permit application for certain permits. Some of the permits were, you know, air permits to construct, certain air permits to construct, permits to install or alter landfills, permits to discharge waters into the state. There were a couple others as well. But essentially when the state gets an application for one of these permits, they have to do an analysis, and within that analysis they have to consider you know, not just the pollution from that one proposed facility, but also pollution from past, present, and foreseeable future facilities in that area as well. And then once they do that assessment, they're not required to, but they can use that assessment to either deny a permit or modify the permit's conditions. And then when the state issues either a tentative or a final determination on the permit, they have to include that assessment as part of that determination so that the public can see it. In the end, so that was the initial bill that started, that was introduced into the legislature last year. It was cross-filed, so there was a bill in the House and a bill in the Senate. The bill in the Senate, was amended to only apply to the community I was talking about earlier. When it was amended to only apply to that community, it passed the Senate and then died in the House. So in the end, this bill did not pass last year. But while it was introduced, it did get a lot of support. So it got a lot of community support, it got a lot of health organization support, support from environmental groups, and it also, you know, it introduced this concept and this problem to some of the legislators in the communities that heard about them and heard the testimony from community members and things like that. So some of those supporters have been, since the bill didn't pass, have been working to revise the bill and improve it because there were some issues that many of us thought could be improved. Dr. Wilson, Lee, and I have all been on that work group to try and improve the bill. And so here's just kind of a summary of some potential improvements. The first thing is to add a health component. So the way it was structured originally, it focused on environmental permitting without really getting into health at all, which is really the underlying problem with cumulative impacts, is that, you know, these communities' health is being affected by these pollutants. So you know, we need to add health somehow into that bill, and one of the ways where we've tried to do that is to have a role in this process for the Department of Health and Mental Hygiene. Including them either in you know, requiring them to comment on the analysis process, or maybe it's a collaborative effort between the State Department of the Environment and the Department of Health. But either way, yes. Oh, I thought you were raising your hand. Either way, including the Department of Health would, you know, add at least a little bit of that health component into the analysis. Another improvement to the bill is to increase opportunities for community participation. So some of the permits that were in the old bill already have public participation requirements, but, and I think Leah is going to talk about some of the issues with current public participation. So increasing public participation, especially for the communities that would be, dealing with these polluting facilities once they're sited there. Increasing public participation for those communities is something that we definitely want to, is definitely one way to improve the bill. Another way is to gather better information. So in trying to look and thinking about this bill, we've been looking at other models around the country, and one of the best models for identifying overburdened communities is in California, and they have census tract data on some of the factors I had up earlier, and even more. I forget how many. It's a lot though. Things like air quality data, water quality data, asthma data, infant mortality data, and they have all that data at a census tract level. So a more fine level of data than zip code level data, which some data is that a lot of data is zip code level. So in order to identify overburdened communities better, you need more information. So part of this process should also be gathering information that will help identify overburdened communities better. And then providing better access to information goes back to the public participation piece, kind of. Right now you usually have to write to MDE and ask for information, and sometimes it takes a while. So providing better access to information for communities is also a way to improve the bill. And then the last thing is accounting not just for stationary sources, but accounting for mobile sources, because mobile sources, highways and diesel trucks really can have a negative effect on health. So this is just kind of a general list of ways that we're working to try to improve the bill. And with that, I will give it over to Leah.
Thank you.
Hey everyone, my name is Leah Kelly. I'm an attorney with the Environmental Integrity Project, and I've been working with Emily and a whole bunch of other folks on making some improvements to the bill that Emily just discussed. I'm going to give a little bit of background on our work and then talk a little bit about the problems that we've encountered in that work, specifically focusing on air pollution permits in Maryland. And then the focus of this talk is going to be on two specific things. It's going to be on public participation in the permit process and also on mobile sources, if I'm able to get to that. Public participation may take a little while. So just for some background on our work, my work focuses on environmental justice in a specific part of Baltimore, in South Baltimore, which is shown on this map. And briefly, my organization works on permitting for multiple sources of pollution and multiple types of pollution throughout Maryland. But in our work, we started noticing that a lot of the sources were all in one area, and that a lot of the new sources were also coming into this area. And this area is South Baltimore. It's the two closest neighborhoods are called Curtis Bay and Brooklyn, and this is just a picture of, this is from a couple of years ago, but I think this is 2011, but at that time this was all of the major sources, the sources with major source, which is usually over 100 tons or so per year of emissions, and this is the sources that were active at that time. They're all in this one area. And part of the reason that we focused on this is we took a look at the data on this area, the data on air emissions in the zip code, which is 21226, and this shows there isn't a lot of local data. This is one of the problems that we've sort of identified with looking at community level impacts. But this is from the EPA's toxic release inventory for the last couple of years, showing rank nationally for this one zip code. And you can see, you know, it was in the top 10 zip codes in the country between 2005 and 2009. Dropped to 75 in 2010 and has stayed around there. We think it's likely because there were some additional pollution controls put in at one of the big coal-fired power plants in 2010, but it's still pretty high nationally. And then we took a look at some of the demographic data on, this is the health data, sorry, on the local area. And this is for the two closest, this is census level data for the two closest communities, Curtis Bay and Brooklyn, and you can see that these are three types of diseases that have been linked to exposure to air pollution, and this is from the Baltimore City Health Department. And you can see that Curtis Bay and Brooklyn have about twice the risk for heart disease of Maryland, of that risk in Maryland, and significantly more for lung cancer and chronic lower respiratory disease when you compare it to elsewhere in Baltimore City, to Maryland, and to the United States. And certainly, you know, multiple factors affect this data. It's not just the air pollution, but it's certainly interesting to look at that when you think about the fact that there are a number of very large sources right in that area. We also wanted to take a look at the demographic data for this area, and you can see that the income levels are about consistent with Baltimore City, but they're certainly much lower than national and statewide rates, and unemployment rates are higher than state and national rates, and poverty levels are significantly higher as well. So that's how we got interested in environmental justice, and that's also some background on all three of the examples. The permits and for facilities that I'm going to discuss are for facilities that were located in this neighborhood. So with respect to public participation, for a little bit of background, in Maryland, these are the general rules for public participation in air permits. There's a little bit of difference between major and minor source pollution and deadlines, but generally the public has the right to receive written notice of certain events when an application is filed, when the agency makes a decision to do certain things, and when there's a notice of hearing or a meeting. And the notices are generally published in a newspaper, sent to people who are called interested parties. You have to request to be on the interested parties list in writing. And sometimes they're posted on the MDE website. The documents are available in hard copy at MDE, and then at a location in the area of the proposed facility, which is almost always a local library. The public has the right to ask for an informational meeting on the application. The public must request that within 10 days of receiving the notice. The public has an opportunity to ask for a public hearing if there's a decision to approve the facility. And then there's a written comment period, which is typically 30-day. There's a 30-day comment period, and then the public can ask for a 60-day extension if they ask in writing. And then there's an opportunity to challenge the permit in court. But in order to challenge the permit in court, the general rule is that you have to participate during the review process by either submitting public comments in writing or making them at a hearing. And I should just also mention that this is only for air permits that are issued by the Maryland Department of the Environment. There are some significant air permits that are issued in Maryland by the Maryland Public Service Commission, and not all of these opportunities are available for those ones, and I'll get to that in a second. So the first permit that I'm going to talk about is for a crude oil terminal in this area. This is actually an active permit right now, and there's a deadline of January 7th for submitting written comments on this. And the applicant is asking for a permit to ship 9.125 million barrels per year of crude oil out of this terminal. And there are a couple of concerns associated with this. The primary concern is actually the risk to communities living near rail lines, because back in crude oil, which comes from North Dakota, can be highly explosive, and when trains derail, it's actually caused several fatalities and has over the past year, I think it's about 4 train derailments, but they've caused large explosions, killed 47 people in a place called Lac Megantic in Canada, and most recently in April of 2014, one of these trains exploded in Lynchburg, Virginia. And fortunately, there weren't any people near the rail lines when it exploded, but it spilled quite a bit of oil into a nearby river, the James River. So there are and in addition, there's also air pollution and the possibility of water pollution due to a spill. So it's a pretty significant EJ concern, and the issue with this one is that we actually had a public hearing for this last Monday, and some of the community members, there were a number of community members who attended, and at the end of the meeting asked if this was the first meeting in a series and if there would be more meetings, because they were hoping that there would be more meetings. And in response, MDE said, which was correct, you had an opportunity to request an earlier meeting. There was an opportunity to request an informational meeting, but nobody asked for one. Therefore, there was an assumption that there was no public interest. But of course, people didn't get the notice. People didn't see. And so the 2 problems that we've identified from this are basically the way that people are receiving notice isn't working. In some communities, I think in many communities, additional notice, additional outreach is really necessary. And certainly people would know about it if additional measures were taken to notify people about applications and about proposals. Another problem with the informational meeting is that that there is only an opportunity to request an informational meeting. You only have 10 days to request that. So for instance, if a group like mine gets the notice, I got the notice, you only have 10 days in which to decide, are people actually concerned about this, go speak to people. And so that's an additional problem that led to that outcome. And so this is going to be a separate example of another problem. This is another proposed facility in this same area. This is the Energy Answers trash incinerator. And you can see some of the concerns. It would be the largest trash incinerator in the country, burn 4,000 tons per day of various different kinds of waste stream, including shredded tires and automotive shredder residue, which is the scooped out insides of cars. There are some significant pollution concerns with this one. The permit limit is 240 pounds of mercury, which would be more mercury than all of the coal plants in Maryland combined. The permit limit is 1,000 pounds of lead, 600 tons of nitrogen oxides, which nitrogen oxides contributes to ozone. Ozone can exacerbate asthma, and Baltimore City has some very serious problems with asthma and is also not attaining federal air quality standards for asthma. And there will be 300 to 500 trucks per day associated with the facility. So the permit, this is one of the permits. This is a major source of air pollution, and this is a permit that is issued by the Maryland Public Service Commission. The air pollution permit was first issued in August of 2010, and there was also a second round of permit review associated with a permit extension in 2012. I actually came onto this project in 2011, so I wasn't there for the initial public hearing, but I was there for the second public hearing, which was in August of 2012. And despite all of this procedure, in early 2013, most people in the community still didn't know about the project. And we know about this for a couple of reasons, but one is that we have worked with a group of local high school students who took this on as a project to educate themselves about this facility and to talk to their neighbors about it. And so they started doing that in early 2013, and one of the first things that they did was undertook a pretty extensive door-knocking campaign to talk to their neighbors about the facility, and in doing that they realized almost nobody knew that they were talking to knew about the facility. How much time do I have? And so they've done a lot to inform folks, but I'd want to go back to sort of the problem with the permit process. And there are a couple of this, I think there could have been problems with this even if the permit had been issued by the Maryland Department of the Environment, but there are also additional problems caused by these permits that are issued by the Maryland Public Service Commission. In that process, one has to be a party in order to participate fully in the process, and in order to be a party, one has to file a motion to intervene, which is not something that many community members can do without an attorney. Without being a party in the process, it makes it very difficult to participate fully and to challenge really basic aspects of the process. When I participated in the renewal of the permit extension in 2012, we asked for a 60-day extension of the public comment period, which is something that the public has a right to when MDE issues these permits, but it was very, very difficult to get that. It was a basic thing. Get an extension of the public comment period during this process because we weren't parties. In addition, I think the way that the notices were written when they went out from the Public Service Commission was very difficult. We shared them with some community members, very difficult to decipher exactly what was being noticed. Because this isn't part of MDE's permit process, the public does not have the right to seek an informational meeting the way that they would if MDE was issuing this permit. And then the public hearing that was held in August of 2012 was scheduled at a time that was bad for the community to attend. It was scheduled a Thursday before Labor Day. And a number of folks had raised the fact that this was a bad time. People were just coming back or going on vacations, and also, it would be better if they waited until September after school had started. But it was not those concerns were not taken into account in scheduling. And so the last example I'm just going to give really quickly is of another permit, and this is also located in the same community. And this is there's a coal export terminal owned by the company CSX in the area, and when we first came into the community and started talking to folks, this is one of the biggest concerns that people raised was coal dust from this terminal. It exports approximately 9 million tons of coal per year. It's located very, very close to residences, and people have complained about coal dust. As Emily was talking about, dust that gets in not just inside yards, but inside homes and on the outsides of homes. And this is a local resident showing the dust on her windowsill. And the problem with this permit is that this permit is it's a minor source, and we looked at the renewal in 2013, and there's actually no opportunity at all for the public to participate in any way. The public does not have a right to participate in the renewal of permits if they are minor sources. My group actually was able to sort of maneuver around that, and we did some work on a water permit, and we submitted comments regardless.
What a minor source
Sure.
is and what the criteria is.
Yeah, it's actually based on their specific thresholds for different kinds of pollutants for whether you're a major source or minor source. So in some cases, depending on the facility, it's 250 tons per year. In some cases, it's 100 in Baltimore, because Baltimore is a non-attainment area for ozone. For the threshold is lower for pollutants that contribute to ozone. But in the case of this terminal, the primary issue would be particulate matter, and the threshold is 100 tons per year for particulate matter.
Okay.
Sure.
I had a question, just going back to the Public Service Commission. I'm in state government myself too, but Maryland,
Okay.
Do you see a need to develop some new regulations or something so that the public can have more say-so?
Yeah, I think ideally, I think the process would be reformed in some way I think the process could be improved in multiple ways, even MDE's process, but certainly the PSC process, at least to get up to where MDE's is, I think.
Is it just that the regulations aren't very much developed, language-wise, or what's this?
The PSC actually has it just doesn't have as much detail in it and as many requirements in it. It meets the minimum thresholds of the Federal Clean Air Act, but MDE has additional requirements. But in addition, I would also add that I think the distinction between parties and interested persons, and the fact that parties are treated as having more rights and the rights of the public aren't recognized as much in that process is very problematic.
Thank you.
I have a quick question about parties.
Sure.
When can a group intervene or become an official party?
It's actually governed, so you have to file a motion to intervene in order to be a party, and the legal standard, the judicial legal standard for filing a motion to intervene is you have to do a timely application, and that's all that it really says, is it has to be timely.
You don't find out about something
Yeah.
right when it's starting.
If you find out 2 years later, we actually did this, if you find out 2 years later, if you find out a while later and you file a motion to intervene at that part, it can be, at that point, it can be denied.
Is there anything to preclude the public integrity department, one for public interest legal entity in Maryland that I did not know about? We've got scanned. Is there anything to preclude you from filing a motion to intervene every time on any issue that the PSC is heard, and then choose at a later stage whether or not to be representative of some interest?
Could you repeat the last part of that, I'm sorry?
File a motion to intervene
Mhm.
on every issue before the PSC and elect later to determine whether or not you choose actually to intervene representing some interest. But file,
EIP would file no matter what.
so that there will always be the potential for you representing as a party of record any interest that might arise.
There's nothing that would prevent that, no. I mean, I think we're not so much concerned about ourselves as citizens, like members of the public.
But you would allow, by filing the motion, it would be established that if there is an interest out there that wishes to represent its interest on any individual issue, you've already filed the motion and they can piggyback on your motion.
That's actually a good question. You do have to file a motion on behalf of the person who's planning to intervene.
The public. The Public Integrity Project would be filing on behalf of any interested public on whatever the issue is.
We'd have to, that's not that easy of a process. We'd have to then go find somebody, talk to them, see if they wanted to.
Well, that question relates to the fact of notice. The opportunity for the public to read, and very often we don't.
That also puts the burden on us as opposed to the agency. I mean, we're a small
I'll
organization.
say news.
What?
I'll say news.
We're not a membership organization. What?
Notice to the public is required, but it's quickly a retreating requirement. Many entities, including Prince George's County most recently last month, is chipping away at the requirement to notice the public. We don't need it anyway, unfortunately, but that's less of an opportunity for the public. I mean, it might be more of an opportunity for the public in the future if you don't file this and you say, I didn't know anything about it, it wasn't in the paper, because the legislatures are taking away their requirement. The requirement is on them to notice the public on individual issues.
So let's
It's
hold,
an interesting concept.
yeah, let's hold additional, we can come back to that during the Q&A, so I want to make sure Leah's able to finish,
Yeah.
and Lisa gets a shot.
Okay.
Go ahead.
So just briefly, just to reiterate the point here, in the case of renewals of minor source permits, so this is for existing facilities, the public really, unless there's a new pollution source, the public is essentially without the right to participate in the process. And so we've looked at a couple of possible solutions. The biggest problem is really notice, is making sure that people, actually learn about things. And so we've discussed a couple of things in terms of how this could be improved, and Lisa may be able to speak to, EPA has issued some guidance on this as well. But some of the things that we've talked about are having an easily navigable permit website with all of the information where people can just look. If people want to say, I wonder what's going on in my neighborhood, just look at the website. And, we understand in some of these communities, not everybody has computers, but in some places there are excellent schools, students have access to computers and to websites, so that's one idea. Another is to look at, community-specific outreach mechanisms. For Curtis Bay anyway, we found that some of the best ones, and this is from the organizers that we've worked with, the best practices are pretty much door knocking, in-person meetings with multiple groups, and sending flyers home with students. We understand that this can be burdensome, so we've also talked about a couple of possibilities that aren't quite so burdensome, but those would still, you'd be looking at notices to multiple groups and all residents. Additionally, more time to request an informational meeting on the initial application we think would help a lot, or an automatic informational meeting, and the right to participate in renewals of air pollution permits for existing sources, like the CSX coal export terminal. And I'm gonna touch on air pollution. How much time do I have? 1 minute, okay.
Yeah, because you want to give us some.
I'll go through this quickly.
Take about three
So
minutes.
air pollution from mobile sources, such as trucks, trains, and ships that are associated, and this is when they're associated with the stationary source facility, so not sort of all, but when a new facility comes in and they're gonna have, a certain number of trucks, or there'll be a certain number of trains associated, how can you look at that as part of the facility? And this is Curtis Bay. Some of these things aren't relevant, but mobile source pollution is a big problem there, and it's one of the first things that people will talk about when you ask them about the concerns in the community, specifically truck traffic. These two, the yellow spots in the middle of this are the heavily trafficked areas in the community with heavy industrial truck traffic. A lot of it is industrial tankers bringing petroleum products. And there's also the CSX coal train yard, and basically folks just say, there's a lot of soot, there's a lot of noise, safety concerns about, children, and I've actually had somebody tell me that they're worried that the foundation of their house was damaged by trains coming so close. And so just briefly, the Energy Answers incinerator, which I discussed earlier, is going to bring a lot of truck traffic, and these are not considered when the agency looks at the air pollution and the effects of air pollution. This is not considered in the overall air impacts review. And the same thing is the case with the Targa crude oil terminal. There will be crude oil trains, which bring diesel emissions, benzene leaks from crude oil trains. There'll be trucks, which bring diesel emissions, marine vessel emissions, which will include diesel and ozone-forming chemicals. And there's also an additional risk, which is safety risks, that is not sort of also considered in this. So we've discussed ways to try to make sure that these are also considered when a new facility seeks a permit, if you can look at the emissions from the mobile sources that will be associated with that facility. And we're still considering that a little bit, but the things that we've discussed are basically, some requirement to assess the local impacts of the mobile source pollution in the actual permit review, and then some authority to mitigate those local impacts. We think would be an improvement. So that's everything.
Thank you.
Yep.
So you have any additional questions? Let's hold them to the end. You have about 15 minutes.
Oh, okay. Well, I think we should probably get to the
Discussion.
discussion quicker. So I'm Lisa Garcia. Oh, no. Okay. Lisa Garcia with Earth Justice, Vice President for Litigation for a kind of new program at Earth Justice called Healthy Communities. So, and I've only been there for 5 months, so hopefully maybe next year I'll be able to report out on the new initiatives at Earth Justice. But one of the reasons that I was asked to speak is because I, 5 months ago, was at EPA as the advisor to the administrator, politically appointed by Lisa Jackson and the Obama administration to advise on environmental justice work in 2009. And so it was this great opportunity to come into the federal government and take on the priority of environmental justice at the federal government and really kind of restart the engines on environmental justice. One of the actions that we took was to work with the other cabinet members on an interagency working group on environmental justice, and some of my colleagues are here from the other agencies. But so I was asked to talk about federal legislation, which means I should probably sit down. Because the new agenda is to get rid of the EPA. So as far as like looking into the future, do we see any environmental legislation? No. And then I can sit down, right? But I'm here to talk about a little bit of how we can, looking at federal legislation and existing law, fill in the gaps of some of the work that Emily and Leah were talking about, that, you have city governments who are working on issues like siting and local zoning laws, and how do they look at permitting or assessing some of the impacts to communities, and how are they looking at issues like equitable development. That's really on a city level. And then you get to the state level, and there's the delegation of some of the air permits and water permits. In New York, I worked on brownfields legislation, which is really how the state is looking to clean up sites and then thinking about how we revitalize those contaminated sites. So there's opportunities, I guess, at every layer of access points, I should say, that, in city and state government. And so I'm going to talk quickly about some of the federal, how the federal government or legislation fills in those gaps or can complement it. And basically it comes down to taking existing laws. So there is no environmental justice law. There's no law that says this community is overburdened, there's cumulative impacts, there's clustering of facilities. I mean, I worked on issues in the Bronx before I went into government, and it's like classic issues that communities are faced with. And one of the things that looking across the country, there's no legislation that addresses that. That if you have these issues, as Leah laid out, the demographic, the health impacts, the clustering of facilities, you should no more permits until we address the legacy issues that are happening. So what happens is you have to look at existing laws. And what I find, and I think what we're all sharing up here, is that there are tools that we can avail ourselves of within those existing laws and legislation to really get to some of those impacts. And one of the ways that the federal government is trying to complement that, I would say, is trying to support the engagement and advocacy from the public. So really focusing on what we called at EPA, when I was there, we did enhanced public participation. And so someone was raising the issue of notice. One of the guidances that EPA put out, I think it was a year ago or something, was focusing on this issue that if you are the owner of a facility and you know that you're going to expand, or you know that you're about to place an application in, why not also, like you give notice to the mayor's office, why not also give notice to the community? And I get that sometimes, it may just be the community leaders, but I just heard earlier this snowball interviewing concept, which is kind of interesting, that if you give the notice to the leader, that you can ask some of the community leaders, who do they know that they can talk to? So it's a little bit like the knocking on doors, but really kind of embracing this issue of enhanced public participation. And then the other thing that I think the federal agencies are focusing on and trying to help with this issue of not only should people be at the table and participating, but what kind of data access do they have? What access to information is there, so that not only are they sitting at the table, which is important. I mean, we're all at this EJ conference, right? It's Environmental Justice 101, that everyone gets a seat at the table. The other important piece is what information are they bringing with them? So EPA and some of the other agencies are really working to figure out what those health impact assessments would look like. What would it look like to have some of the stressors that Emily was showing? What does it look like to be able to access traffic data and cancer rates and demographic data maybe in one place, so that when you have a seat at the table, you can come and say, we're talking about impacts because we have all of this data. And some of the data from HHS, for instance, on asthma rates, skyrocketing asthma rates in the exact same neighborhoods that are getting the incinerators, in the exact same neighborhoods that don't have access to health care, in the exact same neighborhoods that have skyrocketing unemployment rates. But at least equipping ourselves with that kind of data gives us much more influence, I would say, in changing how people are beginning to look at some of the decisions they're making. And then, of course, I would say there's the legal tools. So beginning to look at some of the opportunities where lawyers would call it that discretionary place, that you can, the goal isn't only to issue permits, but if we can look at some of the discretionary points, you actually do have the ability to take into account environmental justice concerns. That if you're saying you are looking at an air permit, to say that you don't have the ability to look at cumulative impacts is not correct. It's about how we gather that data and talk about it and think about, so if you have, one of the things that we were working on, and EPA is still doing this with a lot of help from the other agencies, is in the environmental assessment during the scoping points, can you include a health impact analysis? Can you include some of the background data from mobile sources to really get a picture, a snapshot of what that, how that community lives and exists, and what are some of the mitigating issues that we can put on the table. And I think those are, from my perspective, it's not panacea, it's not, we're not getting maybe as far as we need to go to really protect certain communities, but that we're beginning to change the way people are coming to the table, the way they're equipped with information and data that suggests that this needs to be a changing system or a changed decision-making system, and really beginning to see change in a lot of the communities that we're working with. And so I would say that's how kind of the federal government is looking at it, and is how to complement some of the work that's going on. And so I'll just quickly, since we want to get to the conversation, once again, under NEPA, the environmental review process, if there is federal funding, I don't know if the Bach and Crude one, an expansion of a rail yard, for instance, probably gets federal funding. How do you look at the environmental assessment and suggest these health impact analyses, HHS and other agencies are looking at that potential? How do you ensure public input early and often, translation of documents? And there is documentation of how agencies are starting to look at EJ concerns, looking at demographic information and some GIS mapping to get to some of those impacts. Permitting, once again, enhanced public input. There's a process right now to get permitting to also look at addressing actual concerns. So what are some of the mitigating factors that you can work with the applicant? So even if you could start earlier and leave the state agency out of it, I know sometimes it doesn't always work, but if you could work with the applicant, then when by the time they come in, walk in with an application, it has those community benefits, and you've heard of community benefits agreements or community advisory boards. These are the type of things where we're saying community needs to be involved from the beginning with what's going on. In rulemaking, there's an effort to have more monitoring to allow for more enforcement. So a community gets copies of those monitoring reports. You know, like a lot of communities aren't even aware that the permit, a lot of times with a federal permit, you need to have annual reports, and sometimes that'll show exceedances. Sometimes if it's a huge exceedance or a violation, they have to issue it within six days. So asking for some people to get access to that information. And then I would say, of course, we always talk about participation, and I think the federal government has been looking more into how they assess applications for grants. So more grants to indigenous populations and to communities that maybe don't have a 501c3 but can partner with someone else who does, for this capacity building, to be able to get to the table with the data, with the information, maybe with an expert to participate in that process. And then, sorry, under NEPA, in case anyone does work on these issues, there's an effort to also accept some of the native, certainly with Alaska Natives and other indigenous populations, the indigenous ecological knowledge, tech, right, in evaluating the impacts. And so this is a change, and it's getting to a place where we're understanding that communities bring information, are experts on what's going on, and that these are the things that need to be evaluated. So, so that's kind of how the federal government is participating and helping out more on trying to use the existing laws and equipping participants. I mean, obviously you have to file to be an interested party, I guess, which is a whole issue of notice. But if you can get in the door and you are a participant already, hopefully the federal government is starting to give out more and more of that supporting information and data that you would need. And that's it. Thank you.
So, thank you, panelists. So we're gonna take about, because, you know, since I helped to organize this event, I know how things go. We have our plenary sessions. I know it's gonna be, everyone's gonna wanna talk, but those sessions are gonna be tight. They're shorter sessions. So we have 15 minutes. We're gonna be on time, okay, folks? So let's go with the questions. Yes.
Yeah, thank you. My name is Mike Beckham. I'm with the District Department of the Environment. So environmental justice, it's a broad issue. The definition would be, one way of defining it is fair treatment, meaningful involvement with regard to minority populations and low-income populations with respect to the implementation, the development, and the enforcement of environmental regulations, laws, and policies. And so a lot of what you were talking about was perhaps you could say the implementation of regulations, permitting, and making sure that there's fair involvement. With the lack of federal legislation, you know, we have Executive Order 12898, Bill Clinton's Executive Order on Environmental Justice, and also Title VI. But beyond that, there's not a whole lot. Have you all, in your research, looked at state programs, state legislation with respect to maybe community advisory groups? You know, interagency working groups also work with permitting and requirements for community involvement. I'm wondering what can states do at that level to make sure that environmental justice is ingrained in the programs, policies that they do.
So who wants to take that question? I think any of us can, but I'll let one of y'all go.
Well, so I'll kick it off, but I'll say that the federal permitting schemes set the floor. And so I would suggest if you're an interested state, the states can go pretty far. I mean, obviously they have other stakeholders to worry about. But that if you, so generally there is the ability for states to take it even further. And I think that there are some states, we know some states have interagency working groups on environmental justice. Maryland is one of them. They have the
South
commission.
Carolina.
Yeah, South Carolina, New York. Other states like California have taken on actual legislation to look at some of the cumulative impacts, which has mixed reviews. But the point is that the state implemented it through one of its climate change regulations. And then
Minnesota.
Minnesota also. So there's huge opportunities, I would say, for states to take the lead and take existing permitting schemes and add to it and make it more enforceable or add community desires. I would say that in Connecticut, there's actually a law that was passed, actually under Gina McCarthy, when she was the commissioner there, for certain facilities, and I think this is similar to the Maryland legislation. For certain facilities, before you get a permit, you have to have a community agreement, a community benefits agreement. And once again, with mixed reviews, but there are states that are taking it a little further.
And so and then what about the EJ order in Mass? You have, what's that?
Oh, yeah, the new, so I think
There was a recent, very recently, just a half ago,
Last week.
Deval Patrick in Massachusetts signed an executive order on environmental justice there, and it's going to have, there'll be multiple pieces of that. There is an interagency work group as well as an advisory council to the governor. There will also be an environmental justice director in the main agency that deals with environmental issues, and environmental justice coordinators in each agency that work with the environmental justice director. Massachusetts has an environmental justice policy, and they're going to revisit that and probably the definition of environmental justice population, which I think that's one of the very important pieces when you're looking at state level, because if you're going to look at doing enhanced public participation, you really need to look at where that's necessary, and it's hard to do that if you don't have the data. As Lisa was discussing in her presentation, if you ever need to look at where the health workers are, so I think that, you know, the data gathering is probably sort of a preliminary, piece to then do enhanced public participation. So those are a couple of pieces of that new, executive order in Massachusetts.
So I just wanted to add quickly, I'm sorry, in New York State, there's the enhanced public participation piece that the Environmental Commission runs. But they also have an environmental benefits policy, so if there's a settlement of any enforcement action, it's like a supplemental environmental project, but there doesn't have to be a nexus. So if the community wants waterfront park, that you could have in your settlement, you could have money for the penalty, but then also some of it can be sliced off to go back to the community. And then they just passed power plant legislation, which is Article 10, which actually has an environmental justice review piece to it if you're citing anything that's 25 megawatts or more. It speaks more to energy efficiency and renewables going out to communities, but you see states are beginning to take those steps. How are we beginning to mitigate? Once again, there's no legislation that says you may not permit. It's how we're going to get to a better place and improve quality of life.
So, here first.
Hi. So I'm Sydney Daigle with the Prince George's County City Council. I think this is really a follow-up question, but do you have any examples of counties that have institutionalized HIAs into their planning and permitting processes?
San Francisco Health Department,
Okay, San
Oakland.
Francisco Health
So
Department.
the best model for HIAs would be Oakland, and just, you know, Lisa mentioned about NEPA. You know, NEPA, the problem with NEPA is it only uses the word health once, with health for environments, it's nothing about healthy people. So that's been probably the best model for the integration of HIA into environmental decision making in the country.
San Francisco.
My name is Michael Hartman. I'm with Greenbelt Climate Action Network. I think that what you're saying is sort of like what they said in the disability community, which was nothing about us without us, for your participation. But I'm wondering, are there any other legislation that you're working with on a state level, that, like a wish list or something like that, other than the cumulative impact bill? What other kinds of bills are you looking for in Annapolis this January?
Who should
No,
answer?
we're not.
You want me to answer
This
that?
is it. Well,
What do you want me to do? Say nothing or say something?
I will say something and then you can say
Okay,
something.
okay, cool. Go ahead.
I mean, I think that right now we're just looking at this one bill, but certainly there are multiple other things that can be addressed. Two that I'll mention are, improved monitoring in areas, ambient air quality monitoring, so you have data on the specific reasons of concern. There is no air quality, the closest air quality monitoring stroke 2 Princeton is 1 mile away. And another one I would say is also, and these are both things that'll help multiple people, but I think in communities especially, and another one would be increased public transparency and access to data. Increased, for example, emissions inventories posted online, so people can easily access them, things like that.
And just because I'm part of so we didn't talk about this, but we'll talk about this tomorrow. We have a DMV Environmental Justice Coalition. As part of the Environmental Justice Coalition, we have a legislative work group. So we have a legislative work group that's trying to work on various issues. But one thing that's important that Lisa and I think the panelists mentioned, health is key to this. So with the Maryland Health Disparities Health Improvement Reduction Act, they have health enterprise zones. That provides a foundation for getting at these cumulative impacts and burdens in an efficient way. So, I mean, that would be one place to target. It's already there, that we can use that to really address environmental issues and environmental injustice in the state better. Let me come in the back first. Yes, ma'am.
Thank you. The panel is great. Kim Lambert with Fish and Wildlife Service. I'm not here to represent the federal government. Blacks in Government. I'm the president for the Department of Interior. Here's my concern. I see no way, no how, any proposed legislation is going to pass. Even if it does, it won't have any teeth, and I'll tell you why. There was, we just had the election, November 4th, here in Maryland. A lot of people were running for office. I was helping someone running for state senate. Every one of those who were running for office made it abundantly clear for PG County, if there's a hole, we're going to dig. We're going to bring in more businesses because we're bringing in more jobs. So they are gung-ho. You won't find one who said, we're not gonna do it. So what can be done to work with the Maryland state legislation or the assembly, because they have made promises to these communities that we're gonna bring in more jobs. So when you talk about the noise, the trucks, the pollution, it's only going to increase because these are promises they have made.
Yeah.
I have just one response to that, and I would say, I can't really speak to specific legislators, but it doesn't necessarily always have to be a choice between jobs. It should be a choice. There should never be a choice between jobs and health. But I would also say that it doesn't necessarily have to be that you're going to deny the facility. I think you can look at taking a closer look at all of the impacts that may be associated with a specific facility or with additional mobile sources. So taking a closer look and then potentially mitigating in different ways. And as Lisa pointed out, there is a lot of discretionary authority already to do some of these things. But if additional legislation was passed that gave even more authority to do it, it's not necessarily a death knell for any proposed projects. If you want to take a look at how you can mitigate truck traffic, maybe route it away from communities. There are ways to require additional protections without having to deny a project.
So, and to be real quick, so you make a really important argument. It's a classic argument when it comes to EJ issues. A lot of these bills and things we talk about, they don't have to be negatively framed. They can be framed as pro-health bills, pro-family bills, pro-job bills, right? It depends on the types of industries you're trying to bring in, which really have minimum impacts on the environment and human health and maximum benefits to community. Many times the jobs that come into these communities, as you know, they're really short-term construction jobs. The jobs that the residents actually get are not living wage jobs, and the jobs actually high-paid wage jobs that people don't even live in the community. So you host it, but you don't benefit from it. So we're talking about really bills that are really more about positive revitalization and really about sustainability, where we're talking about economic and social sustainability. These bills and EJ regulations can really help with that, but it's flipping it and really showing the true benefits of these types of bills and the true cost of when you don't have that in place. Okay, let me go to you first.
I live near Cove Point, Maryland, and there have been approvals of permits by FERC and MDE of that facility. Those of us who live nearby feel that there were major flaws in the permitting process. Both the applicant misrepresented significantly facts relating to what they were going to be producing, and we feel that local officials understated data that was given to the company as to what the impact was going to be on the local community. My question is this: most of your focus was anticipating a permit or in the process of processing the permit. Are there legal grounds for going and appealing a permit that's already been issued if it can be demonstrated that there were misrepresentations of fact in the initial application and the submission of inaccurate information by local officials that led to decisions at the state level?
The statements of false information in applications, I'm not so sure about. There are definitely enforcement actions that can be taken, but once again, it would just be to modify. So, I don't know, years ago I worked on a permit and they said that during startup shutdown, it would have this amount of emissions. And we went back, reviewed everything through this monitoring and reporting. That came out, went back, sued them saying that they estimated this amount and it's actually this amount. And what happened was they just went back, tweaked the permit conditions, they had to fix the equipment and the facility is still there. So there are opportunities under the Clean Air Act or whatever permit is, Clean Water Act. I assume the states usually, in Maryland, it's delegated to the state. So there's opportunities. I don't know, there's someone from DOJ back there. They wanna, oh, here.
No, so use the Administrative Procedure Act.
Can you translate that into English?
Yeah.
I'll be happy to ask.
Yeah, let me get. I had two more questions. You want to give, and then I'll come back. You last. Okay, cool. Go ahead. Go ahead, Liz.
Oh, thanks. This is a great panel, and I commend with the Environmental Integrity Project and those young people from Curtis Bay. Really, I mean, if you guys ever do an award at this conference,
We need to.
you
That's
know,
something I
those
thought
young people
about.
should get the first award.
Yeah, that's what I thought of. That's a great idea.
Something that I struggle with all the time, and I don't know, there's no silver bullet answer, but I'm gonna throw it out there anyways. You know, I'm always struggling with the fact that we are constantly asking for, oh, we need more data, we need more data. Pushing the burden on the communities to do everything. We keep pushing the burden, pushing the burden. When we want increased monitoring, that is for the, that's an additional burden on these communities. An additional burden on the very few people who can work on this stuff full time. And I really worry about this because it's simply not possible when you have 2 regular jobs and trying to take care of your kids and you get a stack of documents if you're lucky, okay, to try to figure out what this stuff is. And it's very rarely a battle of the lawyers, it's a battle of finding an expert. And they're very hard to find and they're very expensive, okay, because they got to eat too. If you're lucky, you can find University of Maryland, or some other local university or some graduate student. But most people, and I just don't, all these things we're saying, it's just, it's extremely difficult. This is tough stuff, and I worry so much about, we keep saying this is what we want, more requirements, and we definitely need to, especially in the PSC part, which is outrageous. You only get 10 days, and you have to be an instituted party. But that, to have these requirements, and to have the communities involved in a meaningful way, not in a tokenistic way or any kind of that, is, it is, I just don't know how, I'm trying to figure out how to square that, and if you guys have any insights. Anybody has any insight?
Just to kind of briefly respond and get to the last question so I can get into the next session. It gets back to what Fred mentioned, and it gets back to the point that was mentioned about the haves and have-nots and how the system is set up. So now this is set up, we want to increase participation, but the participation, the burden is more on you and not making it more transparent, more of the data that you can access in an easy, understandable way so you can be responsive and be involved in decision making.
This is the job of these agencies.
Yeah.
These
So it's been pushed to, so that's a really good point, but I don't know, that's a bigger conversation. So let's get to the last question. Yes, sir?
I work on Capitol Hill as a health policy government. I work the Constitution Bill, instead of on the National Youth Conference Committee. My question was kind of going back to the economy in terms of, because I haven't heard much about the green economy or green jobs. So where are we with that in terms of process?
I'll take that one, because that to me, there's a lot of issues with green jobs, and I'm just going to be frank about it. I think there's opportunities, but getting back to my previous answer, you really have to structure and understand what's the economic needs in that community. And part of the reason why we have environmental justice is not just the legislative issues, enforcement issues, it's the zoning, planning, and community development issues. And it's actually the lack of investment by the communities themselves in those communities. So remember, a lot of resources left in these communities that become conditions created for the factories to come in. So you have to have positive investment. So green jobs itself is a great buzzword, but it has to be really investment in education. It's non-health policies impact health. Education, transportation, jobs, schools, housing. And you have to have investment dollars going into those things to really improve the tax base, opportunity structures within these communities so they won't be the ones always under attack, because what we know, economic power equals political power. And that really undermines. So if you're not investing in all those things, you're going to continue to have this cycle that we've been talking about in this session. I'll let you have the last comment.
I was just going to add that I think people are beginning to talk a little bit more about green manufacturing, and so taking the economy and greening the economy. Like we've heard more on green chemistry and
it's a broader scope, the more eco-sustainability. Moving from a capitalistic system to more eco-capitalism and making sure sustainability is embedded in everything we do. But remember, it has to be social, economic, environmental, and ecologic driving it. So these issues you're talking about, this is more a response. If you deal with the things that undergird you wouldn't have to have this discussion that we've had right today. So thank you for your time. Please, let's get down to the plenary sessions. And they're downstairs in the Hoff Theater. So you have to go downstairs.